Judicial review. In the case of Marbury versus Madison, judicial review is defined as the power of the Supreme Court to say whether any federal, state, or local law or government action goes against the Constitution. So the case of Marbury versus Madison is a landmark case, defines the judicial review process. Now, landmark means the event or development that marks a turning point. Every year, the Supreme Court is asked to review thousands of cases. Of these, the justices hear about 100. In deciding which case to review, the court considers the importance of the underlying issues to American society at the time. As the attitudes of Americans change, the opinions of the court may also change. Issues that were decided years ago may come before the court again, and the justices may issue a different ruling. Similarly, the court might decide to hear a case that a previous Supreme Court refused to hear. The Supreme Court plays a crucial role in American society. The court's rulings have affected how the government works and how the government lives their lives. Some cases are so controversial that many Americans await the court's rulings with excitement or dread, depending on their point of view. The primary responsibility of the Supreme Court is to judge whether the laws and actions of Congress and the President are administered fairly. This function is also known as judicial review. But the term appears nowhere in the Constitution. This important power was developed through interpretation, landmark decisions, and a constitutional amendment. Article 3 of the Constitution calls for the establishment of a Supreme Court and other lower courts. But, like many aspects of the Constitution, the meaning of Article 3 and its implication was left open to interpretation by Congress. The first Congress passed the Judiciary Act in 1789, establishing the Supreme Court, 3 circuit courts, and 15 district courts. Congress also appointed a Chief Justice and 5 Associate Justices to serve on the Supreme Court. Yet the court's powers were still largely unidentified. Through the court's interpretation of the Constitution, in particular cases, its powers were gradually defined. The first of 3 Chief Justices had little impact on the direction of the courts, but the actions of the 4th are still felt today. So the Judiciary Act of 1789, act that created 3 levels of federal courts and defined their powers and relationships to the state courts. It set up the federal districts, set up circuit court appeals, and President nominates the federal judges. On February 17, 1801, President John Adams, and this is John Adams here, a member of the Federalist Party, lost his bid for re-election to Thomas Jefferson, a Democrat-Republican. Even before the presidential election was decided by the House of Representatives, it was clear that the Federalists also lost control of Congress. For the few months before the new president and Congress took office, Adams and his party still had control. Adams used that time to take actions that would bolster the Federalist position in government. And the Federalist position was that the federal government should have more control and not the Democrat-Republican Party, which previously had been the Anti-Federalists. And so in U.S. history, Anti-Federalists were those who opposed the development of a strong federal government and the ratification of the Constitution in 1788, preferring instead for power to remain in the hands of state and local governments. Federalists wanted a stronger national government and the ratification of the Constitution to help properly manage the debt and tensions following the American Revolutions. Formed by Alexander Hamilton, the Federalist Party, which existed from 1792 to 1824, was a culmination of American Federalists and the first political party in the United States. It was the first and only Federalist Party. President Adams, right here, persuaded Congress to pass the Judiciary Act in 1801, which gave him the power to appoint new federal judges. Adams appointed 39 new judges who shared his political belief, and that was that the federal government should have all the power, or most of the power, not the state governments. Adams appointed 39 new judges who shared his political beliefs and who would likely oppose Jefferson's policies. But at the end of his term, Adams' Secretary of State had failed to deliver 3 of the commissions for the new posts. One of the commissions was for William Marbury. So, of the 39 appointments that Adams had made, 3 of them were not delivered in time. And William Marbury, one of those was his. So what would Thomas Jefferson do, the new appointed president? When Jefferson became president in March 1801, he discovered the undelivered commissions and instructed his Secretary of State, James Madison, there's James Madison, to refuse the appointments. William Marbury, angry and frustrated, took his case to the Supreme Court in an attempt to gain his post. He asked the court for a writ of mandamus, forcing Madison to make him a judge. And the writ of mandamus is a document that orders a public official to perform certain duties. Chief Justice John Marshall sympathized with Marbury, but ruled that the Judiciary Act of 1789, by which Congress gave the Supreme Court the power to issue a writ of mandamus, was unconstitutional. In Marshall's opinion, Congress could not give the court this power. Only the Constitution could, and that document said nothing about it. William Marbury never became a federal court, but the court's ruling in Marbury v. Madison established a very important precedent. And precedent means the legal decision that serves as a guide for similar cases in the future. And this is James Marshall. So Marbury versus Madison established a very important precedent in which it served as a guide for later cases. Marshall interpreted the Constitution to mean that the court had the power of judicial review and could overturn laws that it determined to be unconstitutional. Now, precedent, you hear that a lot in legal cases, and that's the legal decision that serves as a guide for similar cases in the future. So, Marshall had interpreted the Constitution to mean that the court had the power of judicial review and could overturn laws that it determined to be unconstitutional. Marshall pointed out that the Constitution is the supreme law of the land and that the Supreme Court has the final say over what is and is not in accordance with the Constitution. So, Marbury versus Madison. This pointed out that the Supreme Court makes the decisions if a law is constitutional or not, or if, in this case, the decision to deny Marbury's commission was legal, and it was determined that because of the judicial review that it was legal to deny him the commission as a judge.